I'm sorry, but don't wanna talk. I need a moment before I go. It's nothing personal. I draw the blinds. They don't need to see me cry. 'Cause even if they understand, they don't understand. So then when I'm finished, I'm all about my business and ready to save the world. I'm taking my misery, making my bitch can be everyone's favorite girl. So take aim and fly away. I've never been so wide awake. No, nobody but me can keep me safe, and I'm on my way. The black moon is on the rise, a fire burning in my eyes. No, nobody but me can keep me safe, and I'm on my way.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. To our beloved lecturer, Dr. Wan Satirah Wan Saman, and our lovely friends and my teammate. My teammate is Muhammad Syarul Adib bin Istama and Muhammad Adib bin Majid. And my name is Muhammad Nur Nakudin Syafiq bin Rodilan. Today, we would like to present about the digital forensic, but in subtopic or topic, balancing e-discovery challenges with legal and IT requirement. Okay, guys, and lecturer Dr. Wan Satira. I will present first, and I will give intro about the e-discovery. What we think about the e-discovery? This is not about the discovery China like in Astro. Okay, e-discovery is about to provide electronically store information, or ESI. What we call it? ESI, electronically store information, to a requesting party, whether it's the government, opposing council, or a third party entity. The progression from one to another allow me or us to better prepare for a career in managing large and complex cases involving electronic discovery. Key elements of becoming a reliable sources in the electronic industry is going to be our ability to translate technical information to ensure that we will understand enterprise content management, data preservation, data collection techniques, queuing, document review, and productions. And we will to provide with additional knowledge as how to navigate a corporate infrastructure and enterprise content, and address each links to e-discovery. Okay, guys.
Assalamualaikum and a very good evening to my fellow friends and to my beloved lecturer, Dr. Wan Satira. Alright, so today I would like to present about Chapter 8, which is balancing e-discovery challenges with legal and IT requirement. For that, my name is Muhammad bin Abdul Majid. I will cover 3 or 4 chapters, which mean the subtopic of the chapters. Alright, so we will go to the definition first. Alright, so the first definition, which is electronically stored information, is information that is stored electronically on innumerable types of media, regardless of the original format in which it was created. In a simple way, the definition of electronically stored information, or known as ESI, is data that is created, altered, communicated, and stored in digital form, which is it is born in digital. Alright, so we're moving forward to next discussion, which is steps to locating electronically stored information. This is what I found in the techno books that Dr. gave to us. Alright, interview key individuals, and then inventory network infrastructures, and then we're moving forward to physically inventory on-site records and information that automated tools can access, or physically inventory offsite records. And then the next one is index, archive, backup tapes on-site or off-site. And then the last one, the second last, is determine what is easily accessible and inaccessible records and information. And the last one is sample data collection or restoration technique. So the first point is interview key individuals. So this one is based on my opinion, which is interview what types of media of the information or something like that, and then we go into inventory network infrastructure, which means the place where we start the information, the file itself, and then we divide by two, either physically or in on-site record and information, or off-site the record. On-site the record, which means this one is based on my opinion, is inside the company, which means the information or file is kept or stored inside the company. Meanwhile for offsite, which means it's offsite of the company itself lah. And then the next one is index, archive, backup tapes. This one is labeling of the media lah, so that we not confusing what types of files that has been kept or stored in our company or site of our company. And then the second last is determine what is easily accessible and inaccessible records and information. This one is to give an access or authorized access to the person in charge to keep the what we call information that stored in the company. And then the last one is simple data restoration or collection technique, which means how do we retrieve back the media or the file that we kept in the company, such as by using a keyword or file number, something like that lah. And then alright, so the location of electronically stored information, usually on hard drive, floppy disk, CD-ROMs, DVD-ROMs, USB drive, backup tapes, optical storage device, personal digital system, or mobile. I forget. Seems like floppy disk, I guess. And then now we just using the USB drive, something like that. And then for example, like in our enterprise or company, basically to identify the location of ESI by use of email archiving, records and information management, information lifecycle litigation hold, and document management system. So in company we use the what we call the specific one to retrieve the information or file that we kept. And then so in order to kept the file, we do have appropriate what we call file extension, which is we arrange it by title, subtitle, and then the function of file itself. So for example, like you can see on the screen there, we do have metadata, which is the file name, path, file name, file path, and then document type, email, parent, child, duplicate, and so on. So different metadata contain different description. So this one, they got their own responsibilities by using the metadata.
Today we're talking about the 3 things you must know when it comes to electronically stored information. Stay tuned. This is Tim Santoni and welcome to Risk Mitigation TV. On this show, we want to help you mitigate risk in your business and protect you from those in your inner circle. Today we're talking about electronically stored information and what you as an attorney need to know to protect yourself and your client. First off, preservation. I was recently at an Orange County Paralegal Association meeting where there's a speaker by the name of Terry Mazzura. Mazzura Law is his company, and he specializes in electronically stored information and e-discovery. He indicated that if you know nothing about electronically stored information or e-discovery, the most important thing you can do is learn about preservation. If you preserve electronically stored information at the onset of litigation or even prior to, when there's anticipated litigation, you can save yourself a lot of hassle. 2, if you understand the words of art that are involved with electronically stored information, this will save you a lot of time and give you an advantage over your competition who may not be as well versed. Third, I want to provide some information to you on what the California State Bar says if you don't feel that you have competence in electronically stored information. First, your option is to acquire sufficient learning and skill before performance is required. 2, associate with or consult technical consultants or competent counsel. Or 3, decline the client representation. The California State Bar goes on to say that lack of competence in e-discovery issues also may lead to an ethical violation of an attorney's duty of confidentiality. Thank you so much for tuning into the show. If you like what you see, please give us a thumbs up. We look forward to connecting with you in the comments. Thanks.
So we're moving toward next subchapter, which is legal and IT team considerations for electronic discovery. Alright, so we go to definition of the e-discovery. So basically, electronic discovery, or known as e-discovery, is the electronic aspect of identifying, collecting, and producing electronically stored information in response to a request for production in a lawsuit or investigation. Which means electronic discovery is where the system is identifying and collecting and electronic stored information itself to use as investigation or in any case or in law case, something like that. Alright, basically legal and IT team, it is becoming more common for corporate legal team to dedicate IT professional to their group to assist with litigation whole effort in addition to preserve and collection duties. Alright, so basically the legal and IT team cooperate together to assist in preserve and collecting the information that is valuable.
What is e-discovery? Electronic discovery, or e-discovery, is the electronic aspect of identifying, collecting, and producing electronically stored information, ESI, in response to a request for production in a lawsuit or investigation. ESI includes, but is not limited to, emails, documents, presentations, databases, voicemail, audio and video files, social media, and websites. First, potentially responsive ESI needs to be identified from the various sources where it might be stored, such as from a mobile phone, a computer hard drive, or the cloud. Then the identified data are placed under a legal hold, meaning they cannot be modified, deleted, erased, or otherwise destroyed. Potentially relevant data is collected and then extracted, indexed, and placed into a database. Since this can often amount to a very large amount of ESI data, a process called culling is utilized, during which a large number of emails, documents, and other files are processed and reduced. All the data are funneled through this process, and the quantity of data are significantly reduced by removing duplicate copies, irrelevant files, and by applying filtering criteria such as keywords and data ranges, thereby reducing the number of documents that will require review, which means improving efficiency and reducing e-discovery costs. The remaining content is then hosted in a secure environment and made accessible to reviewers who code the documents for their relevance to the legal matter. Once this has occurred, responsive documents can be produced in what is called the production phase. For production, sometimes the relevant documents are converted to a static format such as TIFF or PDF, making redaction of privileged and non-relevant information possible. The ultimate goal of e-discovery is to produce a core volume of evidence for litigation in a defensible manner. So, in a nutshell, e-discovery refers to discovery in legal proceedings such as litigation, government investigations, or Freedom of Information Act requests, where the information sought is in electronic format.
So the next subchapter is, are you litigation ready? Which means litigation is the process of taking a legal action. This is the commonly used by any parties to against another party at court. Alright, so in terms of these chapters, becoming litigation ready is no small task. However, you need to start somewhere. Litigation in company, it might take roughly more than a year to complete the litigation process. According to this arrangement, I have 4 steps that we can use. The first one is contact your chief information officer or equivalent, which means the person that we trust the most in order to make a good starting point to make the litigation itself.
Hello everyone, we continue to the subtopic e-discovery tools. So I would like to say e-discovery software allows legal professionals to process, review, tag and produce electronic documents as a part of a lawsuit of investigation. The right software can help attorney discover valuable information regarding a matter while reducing costs, speeding up resolutions, and risks. There I have a type of e-discovery tools. I would like to give example of best e-discovery software in 2020. Firstly is about overall relativity, logical, external sideline, Z discovery. So all of this is the best of discovery software in 2020. Okay guys, more to understand, I would like to share about the video e-discovery tools. Let's enjoy.
Technology helps you manage the e-discovery process, perform certain tasks, and make the process run more smoothly and more simply. So for example, in e-discovery, we need to collect all of the documents. Technology can help us find relevant documents more quickly and bring them to our systems to help us analyze them. E-discovery technology has changed from being a series of different point solutions with a variety of different products that do individual tasks to something that's much more platform-based, collaborative within the past couple of years, and the interface has really changed to allow attorneys, paralegals, and other non-technology professionals to do the bulk of the work. I can think of two big trends in e-discovery technology today. The first one is artificial intelligence to really allow you to find your documents, perform your reviews, and other things more concisely and quickly, as well as more defensibly. And the second thing is more of a platform approach to e-discovery, where information isn't passed from tool to tool, but within one tool and across different modules.
In my opinion, a discovery readiness program is not that straightforward. However, by utilizing trusted sources and tools, you are one step closer to implementing a program that works. There are preservation, collection, processing, and review issues, but through team effort, their issues can be minimized. Through team planning, you will be one step closer to implementing a streamlined e-discovery process. But don't stop there. Remember to revisit the plan every 3-6 months since a new technology and methodologies will be available.
Okay guys, last but not least, about the legal and IT team considerations for electronic discovery. When we would like to selecting a member of the IT team to join the legal team in an effort to support our discovery request, we must choose an individual with a number of years in the technology field, designing, administering, or supporting corporate infrastructure. Why I said this? Because when the person in experience, so the job must be easier to be done because he has experience to done before this. Okay, during the gap analysis phase, it is critical to note your current or our current practices as they match up to recommended or best practices in the industry. The business process improvement or BPI phase is easy to implement once we have a game plan or we have the plan to do it. However, buy-in from senior management is also critical. Means that buy-in, like we ask the senior worker to do how to do work about it. Okay guys, thank you for listening our presentations. Thank you all.